Hello there, immigration attorney Connie Kaplan. So I'm coming today to you guys. I'm going to explain 3 different scenarios, and hopefully that gives most of you an idea of how, generally speaking, an immigration process works when someone tries to come to the United States. And really, I'm going to explain the whole process from the first intention to come to the United States temporarily or permanently to all the way to citizenship. So I'm going to break it down, okay? So I'm going to read a lot, okay, because each of them is different, okay? So when I look down, I'm not ignoring you guys. So this is a general overview of 3 different ways a foreign national can come to the United States all the way to becoming a US citizen using various countries, because yes, that makes a difference. Each path highlights time frames, pros and cons, costs, including updating filing fees and some general ideas of attorney fees, visa bulletin consideration, and common issues that we see. Okay, so what is important? Any adverse immigration history, such as prior removal, TPS, asylum proceedings, criminal issues, unlawful status, or unauthorized employment can add significant delays, can lead to denial, can require waivers, or totally disqualify someone from eligibility. So every case is different. This is why most attorneys that are worth anything, most attorneys cannot ever answer that one simple question that every client thinks they have. It's simple, or cannot give you what is it going to cost. So hopefully these 3 examples will give you an idea of how many different moving parts there are and what is it going to take to get there. Okay, so let's start with example number 1. Okay, in this case, I'm going to consider a straight family-based petition for someone from Mexico. For example, in this case, it's going to be a US citizen marrying a Mexican national. So first part of the process is going to be the initial petition, which is filing the form I-130, of course, with everything else that it's required along that. And the filing fee for that is $625. Of course, anything I quote right now is valid at the time of this recording, okay, because those change quite a bit all the time. And the processing time is between 10 and 14 months. That could be faster, could be slower, depending on USCIS workload and consular backlogs. Obviously, the US citizen cannot petition for their foreign national spouse until they are legally married. Okay, so filing the I-130 with USCIS, first step. Second step of the process, once the I-130 was approved, the case gets sent to the National Visa Center, who does further processing before the foreign national is going to be scheduled for an interview at the consulate. The visa fee there for the DS-260 is currently $325. The affidavit of support, it's $120. The foreign national will need to do a medical exam and get a police certificate in their home country, in this case, Mexico, and that's about $500 to $600 altogether. Any translations are about $20 to $50 per page, depending on the type of document, okay? And some of those documents may be translated abroad, some of them may only be translated here. Once the processing is complete at National Visa Center, the foreign national will be considered documentarily qualified, and at that point they are really in line for an interview at the consulate. So we had the I-130 so far, then we had processing at the National Visa Center, that's about 6 months, and then being documentarily qualified until scheduled for an interview could take anywhere between 2 months in some countries and over 2 years in others. Currently in Mexico, it's about 14 months. The attorney's fees For the first part of the process, USCIS and the consular processing, including NVC, are anywhere between $3,500 and $6,000, depending on the case, depending on country, depending on everything else. Now, once they go to the consulate and the visa is issued, then the foreign national spouse from Mexico will come to the United States, and they enter the United States as a permanent resident. It takes about 45 to 60 days after that to actually receive the green card, the permanent residency, but they have the status from the date of entry. Key considerations here, okay? That would be the process so far to green card. So up until this point, if the spouse entered without inspection and they are now going to be consular processed abroad, they will need a 601A waiver. Filing fee for that alone is $795. It takes about 4 to 5 years to be approved, and the attorney costs could be anywhere between $6,000 and $12,000 to $15,000. Unauthorized employment. If the foreign national had unauthorized employment, that is usually forgiven for spouses of U.S. citizens who are just in the United States, but it may be a little bit different abroad. After the interview, remember, only after the interview, the consular officer may determine that the foreign national applicant also needs a 601 waiver and a 212 waiver. Each of those may fix different things. For example, the 601A waiver that the foreign national got before they left the United States, assuming they were here and they had unlawful presence, that is for unlawful presence. A 212 waiver allows them to apply if they had a prior removal order. A 601 waiver, different than the 601A, fixes certain misrepresentations, fraud things, or criminal matters. So each of those is different, and there is a different timeline that you must use, different times when you can actually apply for those waivers. Obviously, each of those makes a difference. So their case could take longer and will cost more if the petitioning spouse is not a U.S. citizen and they are only a permanent resident, if there are criminal issues or a prior removal order, if there were prior entries into the United States with children. If you had more than one entry, you may actually be permanent barred. If you entered with children, by the way, lately what we have seen is charges of alien smuggling. You may have issues at the medical because of tattoos or because of admission to using alcohol habitually or using recreational drugs, even if it is illegal in your country. Prior visa overstays, prior applications or visa denials, or false claims to citizenship. But let's assume the I-130 was approved, you got through the consular processing, you received your permanent resident visa, immigrant visa to come to the United States to get your residency. You are now in the United States. Next thing, what is it that you need to do? Well, if you enter the United States and the visa was issued and you entered before your second wedding anniversary, then you are getting only a 2-year permanent residency. Yes, it's permanent, but it's only valid for 2 years. And in 2 years, you have to go through an additional process to remove the condition on your residency. Now, if you enter the United States after your second marriage anniversary, you have a permanent green card, a 10-year green card, and you can skip this next step. But let's say by some miracle, it moves faster than 2 years and you are entering the United States before your second marriage anniversary, then you need to file an I-751 removal of conditions. The filing fee for that is $750. The attorney's fees are anywhere between $4,000 and $12,000, depending on the grounds for filing the removal of conditions. There are 3 of them. And the processing time is 4 years currently. 4 years. The good part about it is if you are still married and living with your U.S. citizen spouse and your spouse has been a U.S. citizen for longer than 3 years, obviously different considerations. Then you can apply for naturalization to become a US citizen within 3 years of receiving your permanent residency. So, assuming you're filing that in 3 years, if not, you wait the 5 years, okay? Then the filing fee will be $710. The naturalization fee for the attorney would be between $1,500 and $8,000. Remember, all those issues that you had in the beginning will hit you again. And the processing time, depending on where you live in the United States, could be anywhere between 6 months and 18 months. Now, this is the process for a Mexican spouse who's married to a US citizen, from getting married to obtaining the green card, to removal of conditions and citizenship, applying for naturalization. And this process assumes there was no fiancé visa, and it could take anywhere, again, if you add the timeline up, between 5 years and 10 years, okay, which is not for the faint of heart, all right? The cost is between $15,000 and over $40,000. When it takes this long, and with all the landmines that are expected throughout this entire process, pretty much at every step in the way, can you really afford to think it is just forms? It's just some forms. Please give us a call, schedule a booking, schedule a legal strategy session, and let's talk about you. Let's talk about your future. Let's talk about how we can bring your loved one here, how we can fix all those things that have prevented you perhaps from coming before, or how we can avoid all those mistakes and delays and avoid negative and adverse information. Okay, give us a call. The information is right there on the bottom, and let's see how we can get your spouse here. Now, part 2 of this series, it's a different example. Okay, here is an overview of the second of the 3 different ways a foreign national can come to the United States and become a US citizen. In this case, I am going to use a candidate from India with an employment-based path, okay, which is different than the first one in my video, in which I discussed family-based petition for someone from Mexico. Each of these paths that I'm talking about highlights timelines, costs, pros and cons, processing fees, visa bulletin consideration, and common pitfalls, okay? Again, like I mentioned the first time, any adverse immigration history, such as unlawful stays, unlawful entries, multiple entries, prior removal orders, education, experience, unauthorized employment, all of these things can add significant delays and costs, may require waivers, or entirely disqualify someone from an immigration benefit, whether that's a non-immigrant visa, immigrant visa, whatever that is. So again, each case is different, which is why no attorney can answer that question. It's just a simple question. Please give me a simple answer. There is no such thing. And how much is it going to cost? Because there are so many factors involved. Okay, so example number 2, let's talk about employment-based pathway for someone from India. Now, here we are starting from an F1 student visa, then going into OPT, optional practical training, H1B, green card, citizenship. In this case, I am going to assume someone who is not married and has no children. Again, nothing wrong with being married and having children, but that adds time and cost depending on where things change in the process. So first things first, this candidate from India will first come to the United States and, for example, go to school on an F1 visa. The visa application fees for the F1 are $185 plus $350 the CVIS fee. The attorney's fees are between $2,000 and $4,000. Of course, you're going to have to pay tuition for the entire period of time that you are going to be in school. You must be a full-time student and you are not authorized to work. So you're coming here, you are getting a degree. Let's say that degree, it's a 4-year degree, could be 5 years, could be master's, PhD, whatever it is, and you're coming towards the end of that process. Then you would go into optional practical training, okay, OPT. That is after graduation, and it's up to 12 months, 36 months in case of STEM categories. The filing fee for that is $470. The attorney's fees are $2,000, and again, processing time about 2 to 3 months. So far, so good. And then this particular candidate from India would want to transition into an H-1B. For example, they have an employer from the OPT days and times when they worked there that wants to sponsor them for the H-1B. H-1B, everybody is subject to cap unless you are exempt, very limited categories, and you must be selected in the lottery. So you could be going to the whole student visa, get your degrees, but then you may not be selected in the lottery. Assuming you are selected in the lottery, then there is the filing fee is $460, the fraud prevention fee $500. There is a asylum fee that is now included in some of these applications. The acquia fee is between $700 and $1,500 depending on the employer size. There is a premium processing fee of $2,805, which leads to a faster decision. The attorney's fees are between $3,000 and $5,000. Most of these fees at this point in time are paid by the employer. Not all of them, but most. The approval duration, initially for 3 years, it can be extended for over 6 years, especially if you have a green card application in process or it was already approved. So you are on H-1B, you've been on that for say 6 years at this point, and at some point during this process, the employer starts the perm labor certification process on your behalf, okay? Perm labor certification, 8 to 12 months, because it involves multiple steps: prevailing wage, recruitment, then the perm. It's actually prevailing wage is about 8 to 12 months, then the recruitment 2 to 3 months, then perm is another year or so. Attorney's fees paid by the employer between $5,000 and $7,000. Once that is approved, then you receive the labor certification. There is the I-140 immigrant petition, of course, again, with all the other forms that need to be applied alongside that. Filing fee, $715, asylum fee, $300 to $600, premium processing, $2,805, the attorney's fees between 2 and 4, processing time, 4 to 8 months, but it could come down to about 15 with premium processing. Premium processing is not always suggested. Sometimes it's not ideal. That should be discussed with your attorney. Everybody wants a decision faster, but sometimes it's not in your best interest. And then we are hitting the visa bulletin. And this is where the biggest problem comes in for people from India, China, Philippines, and Mexico. Visa bulletin waiting times. India backlog is multi-year, and it could be over a decade for certain categories like EB2, EB3, and so on. You must wait abroad, or you must maintain valid non-immigrant status, such as H-1B, like you had before, until the priority date is current. Let's say you go through that. You had premium processing, visa bulletin is now current. You are now eligible to apply for permanent residency. So you file the I-485, filing fee $1,440, plus whatever fees for the work permit, I think $260. Attorney's fees between $3,000 and $5,000, medical exam $500, and the processing is anywhere between 8 to 14 months after the priority date is current. And then you are a resident for 5 years. 5 years later, you can apply for naturalization, citizenships, very similar process to the first one, to the first example that I said on the family basis, except here you do not have a 3-year option. You must wait the 5 years. After becoming a permanent resident. Again, filing fees, $710, attorney's fees between $1,500 and $8,000, because you again may have issues that need to be resolved. Processing time between 6 and 18 months, depending on where you live. The key issues for India, for example, in this example, extended backlogs, okay? The priority date may take years to become current. That may also mean that adding a spouse to the process or children may increase costs. You're not going to be single and not get married for the 20 years that this might take, or 12 years that this process might take. And obviously, high total cost for this application with multiple filings, premium processing, and attorney's fees, they can accumulate, and they are significant. They are significant. Luckily, for employment-based cases, the employer pays some of these, so it's not exactly bad. Okay. Okay, that's on the second part, second example on how people can come to the United States and obtain citizenship, and that's like the whole process. I don't know why this camera is still moving. Anyway, let's give another example. In this case, I'm going to use Romania as a country, okay? Here is an overview of the last one of the examples that I'm giving you, where a foreign national might follow to come to the United States towards citizenship. Again, I'm going to highlight timeframes, costs, issues, visa bulletin consideration, and so on. Again, as in everything else, prior immigration history, prior removal orders, all of those things may change the process, may change the answer, and can add significant delays and costs, require waivers, or entirely making someone fully ineligible for anything, okay? So each case is different. Again, there is no simple question with a simple answer, and no good attorney is going to tell you how much it's going to cost until they know all the details about your case, because it is impossible. Okay? This path shows fewer backlogs than the one compared to India, for example, but still requires careful consideration and assumes for this particular one that the foreign national is married also to another foreign national, and they got married while they were in school. So the first things first, we are going to assume that they are in the United States, they entered as tourists, for example, visitor visa, they decided that they want to go to school in the United States. So then they are going to either change their status from B2 to F1, or they are going back to the consulate in Bucharest and apply for a student visa there. The visa application fee would be $185, CVIS fee $350, again, attorney's fees between $2,000 and $4,000. They must maintain full-time enrollment in school, and they will not have work authorization. Again, OPT applies if they so decide to follow and actually do that while they are when they're done with school. Otherwise, they can graduate and then they want to transition, they want to open their own business, and they want to invest, for example, and open their own business in the United States and do an E2 investor visa. Now, without including the amount of investment, because the amount of investment varies by business, by location, by so many other different considerations. The visa application fee, again, $185. The attorney's fees between $10,000 and $14,000. There will be other fees necessary for translation, setting up the business structure, licenses for the business plan, for example, that you must have, between $2,000 and $5,000. You must maintain status the entire time that you are in school. The investor can only work in the investment venture, in the business. However, and they have no unauthorized employment, remember that. However, the spouse of the investor has an unrestricted work permit, and they can work for any employer in the United States. And this, guys, is critical, because if the employer works in the business, that gives them status. However, if the spouse is ideally the one with a higher income potential, is the one who's working for other employer, they will be able to find an employer who's willing and does petition for them through an employment-based category. So then the spouse, who's the investor, can also get residency. So again, the spouse has an unrestricted work permit. The term of the visa varies by country. There are some term of the visa is I think 3 months for Egypt, 5 months, for example, 5 years, for example, for Canada and some other countries. So it really varies. However, there is no limit to the number of extensions an E2 investor can apply for, assuming the business still qualifies. Okay, so let's say you've been here for many years, the spouse already went through the entire perm process, like I discussed on the India example, and the process would now transition to employment-based status through the spouse's employer. So that process would be exactly the same as I mentioned into the India example, but again, prevailing wage, recruitment, perm labor certification, I-140, I-485 mirrors the process, but it's much shorter, assuming no major retrogression on the visa bulletin, because Romania, for example, is not one of those 4 countries, China, India, Philippines, and Mexico, where the backlogs are significant. So the same fees that we discussed there would apply. Now, when they are done, again, naturalization for both, and common pitfalls here are unlawful presence or unauthorized work, which can trigger 3 to 10-year bars. Maintaining status for, remember, the B2 that the students had it in the beginning, the F1, then the E2, and then some of these people may qualify, such as the ones from India also, but again, the priority date on the visa bulletin, it's a much bigger issue there than it would be for someone from Romania. And some of these people will qualify for EB1A for exceptional ability, extraordinary ability, or EB2 NIW national interest waiver, depending on their education and experience. So as you can see from all these 3 examples that I had, these are 3 different ways, okay? And these are just 3. Nobody ever follows the entire process with no issues, and it's all clean and no issues, okay? There are way too many factors, way too many, that can change eligibility, timeline, cost, process, each with their own pros and cons, and things can happen at the portion of the process. So proper planning is key. Some of these factors that make a difference, which is again why we cannot have a simple answer to what you may think it's a simple question, or why we cannot give you a fee without knowing everything about the situation, are some of these factors. Your country of citizenship. Country of citizenship may be different than your country of birth. If you have residency in different countries, either you or your spouse, prior immigration violations, immigration court dates, visa overstays, removal orders, any criminal infractions, yes, regardless of severity, okay? Misrepresentation or false data on any visa applications, your level of education, your work experience after you received that education, prior marriages and divorces, other immigration applications filed on your behalf by family or employers, and so much more, so many more different considerations. Hope this gives you an idea of how seemingly simple processes are not so simple. You should always work with an experienced attorney to minimize delays, mistakes, adverse decisions, lost money, and lost time. Time is the only thing that we have that is in finite, very limited amount, and we cannot get back. So give us a call and book your legal strategy session with one of our attorneys and get you to the United States or get you to stay here.